Good afternoon, everyone, and welcome to the latest edition of Trinity Talks, our weekly online seminar program. I am Adekomi Lawson, a Senior Associate at Trinity, and I will be moderating the session today. Today's Trinity Talk, Francophone-a-friend, is brought to you live from Paris. Our Paris office was established to service the increasing number of transactions being carried out in Francophone Africa, and is currently managing 30 active projects in the region. In today's session, Trinity partners Pierre Bernheim and Mariana Sedafian will be talking to you about aspects of civil law in major projects in Francophone Africa, which may be of interest to non-French speakers and those not particularly well versed in civil law. Pierre and Mariana will outline specific aspects of civil law and how they differ from common law, and will also give you a few insights for your projects in Francophone Africa. Many of you, we hope, will already be familiar with the format of Trinity Talks, but for those that are not, Pierre and Mariana will be presenting for 30 minutes, and then their presentation will be followed by a 15-minute Q&A session. Please do use the Q&A function to submit any questions that you may have. So, without further ado, I will hand over to Pierre.
Welcome everyone, and welcome to this Trinity Talk. I'm Pierre Bernheim, and I'm very happy to be with you today. I will be presenting today some specificity about administrative law in Francophone Africa, following an introduction on civil law and OADA law. So let's jump right away on this map of civil law in the world. Here on this map, we have laid out in orange common law countries and in blue civil law countries. You can see that there are quite a number of civil law countries, and you should just remember maybe that even if your loan agreement is probably subject to English law, there is a chance that the underlying project documents and security package would be governed by civil law regulations. Let's now focus on the next slide on civil law in Africa. On this map, we have highlighted in green Francophone African countries which inherited French civil law system from the colonial area. One of the aspects to keep in mind is that most of these countries have included in the Constitution on Independence a principle of legislative continuity, whereby all laws in force would remain in force unless abrogated or unless another law would later on be conflicted. As a result, a number of French law and in force at the day of independence are still applicable those days, and French court case law from the time also could be applicable. In addition, national laws in those countries have evolved also in some instance similarly to French law, and some national courts may refer to current French case law in some instances. I'd like to touch upon OADA law, which we think is really a key legal system to keep in mind when you're dealing with Francophone Africa. Basically, in 1993, 17 member states established the Organization for the Harmonization of Business Law in Africa. We have to keep in mind that this is a technical and legal organization. It's not a political integration. And the purpose of this organization is to remedy the legal and judicial insecurity by modernizing and harmonizing member states' business law so as to encourage investments. And the way to do that is basically that this organization adopts uniform acts. And those acts are basically laws that are immediately applicable in each country, which prevail to national law, and cover a wide range of issues on the commercial subject. Most of them have been adopted in the 90s or early 2000 and have been updated in the past 10 years for the most part. When dealing with project finance transaction, we usually very much use the commercial law, the Commercial Uniform Act, and the Security Interest Act, which Mariana will later on speak about. So this is definitely, I would say, the core laws that we would use in project finance, and they have been very useful in harmonizing law in Francophone Africa. And in most respects, they are quite similar to French laws, so relatively easy to figure out and help transaction going forward in those countries. So what is one of the biggest difference between common law and civil law? Well, we think it's probably the difference between private law and administrative law, which is something that doesn't necessarily is not necessarily easy to understand for common law, for people with common law background. And one of the key specificity is the notion of public service. The idea in civil law countries is that some services must be carried out by the state, such as national defense, social security, but also some key economic activities such as transportation, water, electricity. And as a result, the state would carry out those activities or could delegate those activities to the private sectors, but under supervision. And the way to do that is by granting a concession to a private party, which will set forth the terms and conditions whereby this private party can carry out a public service activity. And most often than not, in Francophone countries, the electrical law will set out that production, transport, and distribution of electricity actually constitute a public service activity. And as a result, in order to produce electricity, you would need a concession agreement. And again, as a result, the entire administrative law related to concessions would be applicable. Moving on the next slide, we'll see what are the specificities related to concession. One of the first specificity concerns procurement. In order to be granted a concession, you usually need to look at procurement regulations. In most of the sub-Saharan African Francophone jurisdiction, you would refer to the West African Economic and Monetary Union Directive from 2005, which deals with public procurement and public service delegation. And this directive has been transposed in those member states. And there are a few articles that deals with the procurement of concessions. Over the past 10 to 15 years, most of those countries have also established public-private partnership laws, which deal in greater details with concessions and PPPs. So you would need to look at which law would be applicable and what would be the procurement system. But the idea is to remember that competitive tender is usually the rule, and direct negotiation is the exception. And you would need proper conditions to enter into direct negotiation usually. Moving on, the next slide on concession-related specificities, it's interesting to keep in mind a few things about land rights. Again, in civil law, distinction, between public domain and private domain. Basically, the states own either public domain or private domains. Public domains is all the land which are used for public services or for the use of the public generally. And private domains are the remaining lands which are not used for the public interest. Usually regulations set out that the state may grant the use of the public domain directly through the concession agreement. which means that basically if you enter into a concession agreement with the government, this concession agreement might deal with land rights directly, and you wouldn't need any additional land lease, lease agreement, or land rights of any sort. So our tip here would be to figure out whether the land for the site is part of the public domain and whether this can be granted through the concession. Another aspect really in relation to concession concerns the ownership of assets. Traditionally, assets which are built under a concession agreement must be classified between three types of assets, either bien de retour, bien de reprise, or bien propre. I'm sorry for my French. Bien de retour are those key assets to the concession which are necessary for the concession to be operating, and are usually built on public domain, and they are owned from the outset by the grantor, which triggers a few issues in terms of issuing security interest over those physical assets. The mitigants being that you would have a pledge over the termination indemnities, and you would conclude a direct agreement with the grantor. The second type of asset would be bien reprise, which are basically assets which are accessories to the concession, are owned by the concessionaire, but the grantor has a right to purchase them at the end of the concession. And finally, bien propre, which are owned assets which are not related really to concession and are owned by the concessionaire. That's it. I think I've tried to cover some key points about administrative law and concession. I'd like now to hand over this live session to my partner, Mariana Sedefian, who will speak about the security package issues in project finance.
Thanks, Pierre, for this introduction and this presentation on the administrative aspect of the project. As mentioned by Pierre, the OHADA countries have adopted a few number of uniform acts to govern to provide for a strong legal framework for investment. As part of these uniform acts, they have also adopted the Uniform Act of Security. This act has been adopted in 1997 and modified in 2011. And it provides today for a very modern set of rules, very inspired from the French security legal system. On this slide, I wanted to draw your attention on some differences between civil law and common law security legislation. Of course, there are some differences, but what I wanted to say is that these are not as broad as before the new Uniform Act on Security has been entered into effect. So one of the main differences is that in civil law countries, we don't have the concept of floating charge. We most type of property of the debtor. Instead, we have pledge over ongoing concern, but which is not really covering all the aspects of the floating charge. Also, we don't have the equivalent of a debenture, which means that we need to have a specific set of rules for each category of assets and rights that are pledged under a very specific security document. Another difference we have in civil law jurisdictions and before the modification of the Uniform Act on Security was how we enforce the security. Previously, we needed to go in front of a court to enforce the security. Now, with this new Uniform Act on Security, it is possible to self-appropriate the assets that are pledged, subject still to some restrictions and conditions. And this kind of self-appropriation is valid for the pledge over shares, which is, of course, a very strong instrument in project finance, and also the pledge over receivables. Another difference I would like to mention is that we don't have a concept of parallel debt. We don't have neither the concept of a trust. However, in OHADA countries, we have now provisions regarding the appointment of a security agent. And today, all the projects in OHADA countries use this type of security agent, which is now really equivalent to the one of the trust under English law. Also, we don't have a centralized system for registration in OHADA countries, which should be good to have for given, like, you know, the pandemic situation we had during those last months. But we need to file with the commercial registry of each country. And finally, some security interests are specific to some financial transaction. I will just mention that in the next slide. So I have mentioned on this slide a few type of security documents we find in project finance transactions. I'm not going to go through each of them one by one because it's quite technical, but I wanted to give you a few insights with respect to some popular, I may say, security documents in the context of a project finance. So with respect to shares, there is two types of security over shares in OHADA. The pledge over securities account, which is with respect to shares issued by corporations whose shares are represented by book entries, and the pledge over shares for the other type of companies. There is also two possible ways to grant security over receivables. The first one is the assignment, which is not actually a pledge, it's an assignment of receivables by way of security. It's really inspired from the French system, the so-called DAI assignment. It is really a very, very strong security for lenders, as it is bankruptcy proof and it gives title to the receivable. Nevertheless, there are some limits to this kind of security because it's not possible to assign a wide range of receivables. It must be defined and determined, and a certain type of transactions could not benefit from the assignment of receivables. Actually, in OHADA countries and in France, hedge transactions cannot be defined as a finance transaction, and they cannot benefit from this type of security. The second way to grant security over receivables is, of course, a pledge of receivables. It's commonly used to grant to take a pledge over bank accounts and a pledge over monetary receivables under a given contract. I would like to point here that under civil law countries, it's not possible to pledge a contract, whereas it is, of course, possible under English law. Instead, in order to achieve the same legal result as we have in English law, you need to have a pledge of receivables over the receivables and then a direct agreement with the contractor. That's for the pledge over receivables. Then I have provided for some less popular security interest, the real estate mortgage, which is subject to registration fees, which are very, very high. These are actually calculated as a percentage of the secured amount, so you can imagine that it's quite expensive. I mentioned previously the pledge of ongoing business, which is quite of equivalent of the floating charge under English law, but it is commonly held that this is of little practice because the value of the ongoing business of a distressed debtor is somehow quite low. And we have also other type of pledges I'm not going to describe here. So much used in a project finance transaction. On the next slide, I wanted to draw your attention on some key items in the bankability of a project as part of the regional integration in Francophone Africa. Means that in OHADA countries, they have signed a certain number of treaties to govern their economic and monetary relationship. Therefore, the monetary relationship is governed for the West African countries by a treaty that has been signed among those countries, and for the Central African countries by another treaty. Both have been signed in 1972 and 1973. In such treaties, we have it has been set the monetary regulation. On the next slide, we can see that such treaties, monetary treaties, are governing the monetary relation between countries of CEMAC and UEMOA. So where is the franc zone? The franc zone is established, as I mentioned, by a legal framework from such treaties signed in 1972 and 1973. And the CFA franc is a currency that has been adopted by those countries. And it is issued by two community central banks, the Central Bank of the West African state and the Central Bank of the Central African state. And the franc zone is an economic and monetary union. As mentioned, its core principles are set out in the monetary cooperation agreements. Those principles include an unlimited convertibility guarantee from the French Treasury, fixed parity with euro, the free transferability, and the centralization of foreign exchange reserves. And in exchange of for paying the CFA franc to euro, and for this unlimited convertibility guarantee, the central banks undertook to place some of their foreign exchange reserves with the French Treasury. However, as you are probably, and I'm sure you're aware, at the end of last year, there has been a modification to the state of regulation in the UEMOA countries, and the reform of the CFA franc has been processed. So on the next slide, we will see that from CFA franc we go to ECO. This the agreements reforming the CFA franc decided to change the name of the CFA franc to ECO. No foreign exchange reserves with the French Treasury will be maintained. The withdrawal of the French officials from UEMOA and BCEAO has been also enacted. But most of the important parts have been maintained. We will still have the fixed parity with the euro and the free and unlimited convertibility of the ECO. Given the uncertainties of the current period of pandemic situation, we could wonder when this reform will finally take place. Initially, July 2020 was the anticipated date in December 2019. Issues with respect to opening offshore accounts, repatriation, and whether and how the principles of free convertibility and fixed parity will be maintained within the larger monetary union of economic community of West African states. And on this slide, I wanted to draw your attention on some specific issues we have in OHADA, in CEMAC and UEMOA countries when opening offshore accounts. Having offshore accounts in project finance transactions is key for the bankability of a project. You must be aware that in order to be in a position to open offshore accounts in foreign currencies, in UEMOA countries and in CEMAC, you need to obtain first a consent and authorization from the central bank, and then the authorization of the Ministry of Finance. In CEMAC, you need to obtain the authorization of the central bank, the BEAC, which will notify it to the ministry in charge of currency and credit. That's the same for opening onshore accounts in foreign currency. An authorization is still needed. There is also an obligation to repatriate the funds. You will need to get the authorization from the central banks, and such authorization must be renewed regularly. I think that now we have arrived at the end of the slide. So probably, Kenmi, if I could turn to you to see if you have any questions on the live Q&A we could answer to.
Thank you very much, Mariana, and thank you very much, Pierre. Yes, we have a few questions that have come through. Seeing as you're on the camera now, Mariana, can I start with you? So, Mariana, you mentioned that the security interests are subject to registration to be valid. Are the registration fees all the same in all OADA countries?
Thanks, Kenny. Well, actually, that's a very good question. Unfortunately, the Uniform Act of Security has established the obligation to register security for perfection purposes. However, it has not provided for a given scale of the fees. So this part is part of the national law, and each country has implemented the fees. So it could be like, a lump sum, or based on the amount of the secured obligations that fees are provided. And for instance, in Senegal, a law has been enacted to provide for quite low registration fees, which is not the same in other countries. Thank you.
Pierre, I think this question is directed at you, although it doesn't say so, because it relates to the concession. Do you always need a concession for an IPP?
Thank you, Kenmi. Do you always need a concession for an IPP? It's a good question. I guess you would need to look at the regulations of the country. I would say in sub-Saharan Francophone Africa, the rule of thumb would be that in most of the cases you would need a concession agreement. One notable exception is probably Senegal, where you actually don't need a concession agreement. You simply need a license to be able, for example, to carry out solar projects. So in Senegal, some projects have been concluded with just a PPA with the national off-taker Senelec and a license agreement from the state and a sovereign guarantees. But otherwise, in most countries, in most Francophone African countries, you would usually have a concession agreement for an IPP.
Thank you, Pierre. And we also have another question for you, Pierre. What type of derogations do you need to obtain to enter into direct negotiations with the government?
Right. This is a question often asked by sponsors who tend to sometimes have some discussion with ministers and would be keen to sign MOU and enter into a concession agreement right away. And we sometimes have to come in and remind everyone that some procurement rules have to be followed, and we've mentioned them quickly during the presentation. Typically, those procurement regulations regarding PPPs/concessions will set out particular circumstances under which direct negotiation could be held. And typically, those circumstances would be emergency. So, for example, if you can argue that there is a lack of power production on the grid and that you need urgently to build new power plants, then maybe you can make the argument that it's urgent to enter into direct negotiations. It would depend some legislation actually have enacted some decrees to say that IPPs are urgent given the state of some national off-takers. Then if you fall in that particular circumstances, you would then need, the Ministry of Energy typically would then need to apply to the regulator, to the department usually sitting within the Ministry of Finance, who is in charge of verifying the conformity of procurement with the procurement regulations. And this department would usually would need to give you basically the green light to enter into direct negotiation. So in theory, you will need to get this green light before starting the direct negotiation. But in practice, we tend to see that sometimes, unfortunately, this authorization is given a little bit before signature instead of before the beginning of the negotiation itself. I'll just add also while I'm on live, as the camera is on me, something to remember. Another specificity with concession is the approval of the Council of Ministers. So in most of those jurisdictions, you need to remember that you wouldn't get an opinion from the general attorney as you would get in some common law countries, but instead you would get a decision from the Council of Ministers, which would approve the signature by the Ministry of Finance and the Ministry of Energy of the concession agreement. So I think that this is one important milestone also to keep in mind in terms of process when you're dealing with a concession agreement.
Thanks, Pierre. Marianne, if I can pass it back to you there, I'm going to wrap up a couple of questions in one about the security agent. One is, are the assets held by the security agent in that capacity segregated from the security agent's own assets? And the second one is a similar question, who takes the security?
Well, on the first one, the answer is yes. The assets held by the security agent are held in that capacity and it is segregated from its own assets. As I mentioned, it's the equivalent of the trust under English law understanding, and it's used commonly now on all the project finance transactions in OHADA countries. It is a very secure and modern and valid instrument, and the security agents are usually appointed on the basis of Article 5 of the OHADA Uniform Act of Security. On the second question, security can be validly granted to the benefit of a given bank, that's for sure. You don't need to appoint imperatively a security agent. It can be granted for the benefit of a bank or banks individually. However, usually international banks or development banks don't have any branch in a given country for the purpose of managing the security. That's the reason why usually a local bank is preferred to act as a security agent.
Thank you. And talking about banks in particular, Marianne, a question in relation to accounts. So in relation to opening the offshore accounts, what does on a practical level, what does a sponsor actually have to do?
Oh, very good question. Very practical one, actually. I must mention that all sponsors and their lenders need to take care of this topic quite early in the transaction and figure out how many numbers of offshore accounts do they need, and then choose their local bank. And then with the help of the bank, of the lenders and the local bank, an authorization will be drafted and sent to the central banks. Careful attention must be paid to the drafting of such authorization, because now the central banks exercise a very stringent control over the opening of the offshore accounts, and currently only 2 or 3 offshore accounts are authorized by the central banks, and they pay attention on the monitoring of such accounts, how they are maintained. And sometimes we have seen in CEMEC countries that the central banks require also the accounts agreement to assess if and how the accounts will be monitored and maintained. In UEMOA countries, it is not yet, I must say, the practice to provide the account agreement to the central bank. But the trend is that the control is more stringent than before.
Thank you very much. We've come to the end of the questions. Just generally, would you have anything else to add to, or just as a general point, as a general wrap up?
Well, yeah, of course. Well, we have tried with Pierre to outline the main issues in Francophone countries. Of course, this is very short. For instance, a whole presentation would be needed to discuss about the topics on security aspects in Francophone countries. Same for the administrative constraints in Francophone countries. So if you have any questions, probably just send us an email and we will be very happy to answer to your question.
Thank you very much, Mariana. And we just have enough time to tell you about our upcoming talks. So on the 22nd of July, we have a EPC FM talk, calling force majeure in construction contracts, which is followed on the 29th and the 30th of July on a two-part presentation on partial risk guarantees. And then on the 6th of August, we have a presentation from our US office, which is a special relationship company, New York, and English law aspects in project financing. You can find all of our talks on our website, and we hope that you enjoy them, and we hope that you attend the future talks. Thank you very much.